Welcome, everyone. I thought we'd get started right on time today. It's my great pleasure to welcome you to this afternoon's discussion on justice, equity, democracy, and inclusion, as our presenter refers to as the JEDI program, which I think is fantastic. I'm Jens Olien, the Alan R. Tesler Dean, Professor of Law, and with me today is our program moderator, Michael Hugh, Cornell undergraduate class of 1984, President of Michael Hugh and Associates LLC, and most importantly, visiting professor of the practice here at Cornell Law School. And our program presenter, Cyrus, Mehri, Cornell Law School class of 1988, partner, Mehri and Scalise. Cornell Law School is committed to sustaining an academic community that is diverse, equitable, and inclusive, a school that welcomes persons of diverse personal identities as equal members who are valued and respected for their individual talents and abilities. Diversity and inclusion at Cornell Law School are definitely not new concepts, nor did they happen by chance. It's part of what makes us who we are. Our inclusive approach dates back to Cornell University's founder, A.D. White. His egalitarian outlook on education lives on in Cornell Law School's mission to train lawyers in the best sense. In a letter to the abolitionist Jared Smith in 1862, when slavery was still legal, A.D. White described his ambition to found a university that would provide instruction, quote, afforded to all, regardless of sex or color. And that he did. When what was then called the Department of Law opened its doors in 1887, 2 international Japanese students were part of the law school's first entering class. 3 short years later, in 1890, the school graduated its first Black man and former enslaved person, George Washington Fields. In 1893, the first woman graduated. Fast forward to 2023, and Cornell Law School continues to attract and graduate highly credentialed students from diverse backgrounds. Since becoming dean, I've established a DEI Alumni Leadership Council comprised of alumni from across the country and across the world, actually, who guide and advise me in DEI initiatives they are seeing and experiencing in the legal field. The council's insight helps me and my senior leadership team ensure that we're addressing pertinent issues within the school that will better prepare our students to foster and embrace a diverse, equitable, and inclusive mindset as they launch their legal careers. And this past year, I appointed the school's first associate dean for DEI, Michelle Wayland, who works hand in hand with the DEI Alumni Leadership Council. And 2 months ago, on April 14th, we hosted the school's first ever DEI Summit in New York City. I share this with you as a testament to my personal unwavering commitment to DEI within this institution, to you, its graduates, and to the students who are here now, and also to those who will come after you. Lastly, I welcome your feedback. My door is always open. I invite you to contact me directly with any thoughts on how Cornell Law School can strengthen our first founder, A.D. White's vision. And now I will turn the program over to the moderator, Professor Michael Hugh. Take it away, Michael.
Thanks, Dean. I want to thank you all for being here. I know some of you are at the dinosaur tent, and you're like my students. That's about the time now you start going to sleep. Hopefully you'll stay engaged for this. It's very fortunate for us to have Cyrus, Mehri here, who, of course, is class of 88, but also who I have the pleasure in my professional world of working with very closely as well. In addition to teaching here, I work with a group called the Fritz Pollard Alliance, whose primary responsibilities are to serve as an advocacy group for diversity in the National Football League, where I spent 30 years of my career. Cyrus has had a tremendously deep and impactful role in the National Football League in the hiring of head coaches, and something we'll talk about in the program called the Rooney Rule. And so for this program, we're going to kind of do it almost like a conversation. And I'll prompt Cyrus with some questions covering probably 4 different areas, sort of the moral case for diversity, equity, and inclusion, the business case and the democracy case, and then talk about some ideas of how folks like you can get engaged in DEI and advocacy in whatever capacity you work in. And so just some background, at a time and even in '88 when students were making large sums of money in big law, Cyrus had a different viewpoint of working in public interest and eschewed those big checks to really create passion. And he'll tell you his story as well in our conversation about why this work is so passionate and important for him. He's had a significant role in landmark cases in Texaco, Coca-Cola. We'll talk about some of those cases and how he's really changed and moved the needle on how corporate America looks at DEI, and how Cornell professors have had a critical role in some of the landmark Supreme Court cases that have come down as well. So without further ado, thank you for being here today.
Well, thanks for having me, and thank you all for coming on a beautiful Saturday afternoon.
So you've been featured in every major publication. Let's just start with what sort of got you engaged in this? Why not take the big law? Why go into this area and devote yourself, establishing your own firm in the city and putting your whole career into fighting for equity and inclusion?
Well, I feel very blessed. I think the signature moment for me where I really had my calling happened when I met with plaintiffs at Texaco, Barry Allen Roberts and Syl Chambers, who had very impressive executives, but they couldn't find a lawyer willing to take on Texaco, and they found me. But just hearing their stories, and it kind of brought back to me, I was like, these are kind of like the Rosa Parks of corporate America. They were going to stand up, and their courage exuded that, that kind of fearlessness. And then that inspired me. But also, I think I was predisposed to a lot of this. My parents are immigrants from Iran. They came here by choice, believing in the American ideals and democracy, and came in the 60s. But they also felt the tragedy of racism in America. My mother was kind of an activist, and she instilled that in me to give back. And so that kind of put me on that path.
There's so many reasons why we talk about DEI and its effectiveness. And from a moral standpoint, how did the Texaco case embody that to some degree?
It's really hard to fully fathom because corporate America has changed so much since that. This was in the early 90s. But Texaco was one of the largest oil companies. They ruled by fear. They were particularly hostile towards equal opportunity and anyone who stood up for equal opportunity. They kind of wore that on their sleeves and were kind of proud of it. One of their in-house lawyers, who was African-American, had a meeting with African-American employees, and he was fired. And in a humiliating way, like as if he was like taken out in chains. And as I got into the case, I really felt the kind of fire and passion about what is so wrong about holding people back based on race. Like our clients were, for example, training the people who then would get above them. The pay disparities were significant. There were few, if any, African Americans in leadership, top leadership roles. But what I really kind of broke the case wide open is that one of the executives, who I actually took his deposition, and a year later called me, and as I got into it, we found out he had done tape recordings of the senior executives at the company getting together to shred documents and getting together to say things that are pejorative towards Blacks and Jews. And that really kind of highlighted to me to the extent of lawlessness, the extent of hostility that they would have. Oh, by the way, I wanted to say that this talk today, Justice, Equity, Democracy, and Inclusion, is in honor of one of our classmates from '88, Henry Grandison, who passed away in November. And we dearly miss him. From the first day of common law, for decades afterwards, I was always in a conversation with him about law and politics, sports. And one of our classmates was the true love of his life, Mary Beth Grant, and the two of them got married and raised two wonderful children, and MB's in the back. So just want to shout out to her. And their wonderful children, Sammy and and Charlie, who they raised here in Ithaca, and they both served Cornell University, and Henry, up until the last days, was on Ithaca City Council. So we miss him, and I know he would love being part of this conversation.
So Texaco, in the end, and I'm sure this was one of the examples where you might have been outnumbered on the other side with the legal team defending Texaco. What was the key to getting a resolution in that? How did you really find a way to successfully?
I mean, I can't even begin to describe the hostility they had. They would tell us things along the lines of, we're not going to throw a bunch of money at a bunch of blacks. Literally, that's what they would say, things like that. But when the tapes surfaced, it was a crisis. For 11 days, it was on either the front page of the New York Times or the front page of the business section. All the different media outlets wanted to hear the recordings. Ultimately, Ted Koppel at Nightline played the recordings for the first time to the American audience, and cross-examined the CEO. And ultimately, the CEO basically said on the air, yeah, we should try to resolve it. But it took that level of effort to get them to resolve it. And the cool thing was, it was at that time the largest race discrimination settlement in U.S. history. But the really cool thing about it is we came up with the most sweeping injunctive relief at that time ever done. And we created an outside task force chaired by Deval Patrick, who later became the governor of Massachusetts. And that brought real cultural change to the company.
Amazing. Even in those days, smoking guns were critical for your case. If you didn't have the tapes, probably
we'd still be litigating it, Michael.
Right. Well, let's move on to sort of the business justification. You know,
Sure.
When you talk about diversity, it's rare that people will say, I'm against diversity, equity, and inclusion. But few people will tell you why it helps, why there's a value. What's the business case? How does diversity, other than aspirational reasons, move the needle in business and the business acumen for it? And I know you were involved in Coke and the NFL in some capacity, trying to advocate for that position, but maybe talk about that.
Well, I find that the moral case is not enough to convince the country to go in the direction of diversity and inclusion, that you have to make the business case. And the business case is very compelling when you look at the organizations that exude and value and exhibit inclusiveness and belonging, have a lot more productivity when it comes to their workforces. When we took on Coke, it was another daunting case. I went out on my own. I went to 6 other major plaintiffs firms, and they all turned me down. And they said, well, suing Coke in Atlanta is like suing the Pope at the Vatican. You don't have a chance. And so I basically it's like going to Vegas. I put all the chips on the table, gambled the future of my family economically and the firm. And we took them on. And they were a company that valued African-American consumers, but devalued them as employees and executives. And we had really organized the workforce, kind of a call to action to create change. And ultimately, on the eve of us filing what's called class certification papers, where we had 200 affidavits with compelling stories, they also settled before that would become public. And we created an outside task force, again, modeled on Texaco, but even better in some ways. And that task force was chaired by Alexis Herman, the former Secretary of Labor. So lo and behold, this settlement became a tremendous success for the company. There was a 4-year consent decree. The CEO asked the court to make it 5 years, because they saw the value of this task force and how it led for them from having very few African Americans in leadership to 1,000% increase, but also how it helped them as a business. So, for example, there's a photo here of the freestyle innovation, and that came about when they put a diverse group of people together, brainstormed ideas, and if you go to like different locations, you can choose all kinds of different flavors of a Coke product. And that became a huge growth opportunity for them. So they could see the business case for it. And, you know, they had tremendous progress for about 15 years. They've had some setbacks, and hopefully they're going to get back on track. But the NFL is the most visible way to show, I think, the power of diversity. 20 years ago, I kind of, on MLK Day 2002, I was reading the paper, always starts off with the sports section. I don't know about you, but I started there and I saw that,
Other sections?
there are, I go sports, then business. But I saw that Tony Dungy was fired from the Tampa Bay Buccaneers a couple of weeks after Dennis Green, a very successful head coach of the Minnesota Vikings. And there was only one black head coach in the NFL. I knew they could do better. And I had kind of an epiphany of why don't we use the same kind of statistical analyses that we use in our cases and put out a report. And ultimately, I teamed up with the late Johnny Cochran, a University of Pennsylvania labor economist, Janice Madden, and we put out a report called The Black Coaches in the NFL, Superior Performance, Inferior Opportunities. That report is probably the only report sitting both in the Pro Football Hall of Fame and in the African American Museum in DC. And in there, we put together statistics and anecdotes, just like we do in our cases. But we had in there what's called the fair competition proposal, which was, we're not telling you who to hire. We're not asking for certain outcomes, but we are asking for a more inclusive hiring process. And the inspiration of what became the Rooney Rule really came to me from reading an op-ed by Clifford Alexander, who was a Secretary of Army under President Carter. And he told this story how he said to the Army brass, give me the pipeline of people who are going to be generals. And they gave him a list of colonels. And there was an all-white list. And he said, you're going to tell me in the United States Army there's no person of color who could become a general? Go back and do your homework. And they came back with Colin Powell, added him to his list. And think of how much better America is with Colin Powell as one of our most preeminent generals and leaders and secretaries of state of modern times. And that let me think when we were negotiating the Koch settlement, let's require the use of diverse slate of candidates, women and people of color, for management positions so we can kind of break through the glass ceiling. So I had that idea. And then when Johnny and I went to the NFL, we put that in this fair competition proposal. We had other ideas that they rejected, but they did accept that idea. And that became the Rooney Rule when the reporters called me and they said, well, should we call it the Cochran-Mehri Rule or the Mehri-Cochran Rule? I said, no. Let's call it the Rooney Rule because Dan Rooney, the owner of the Steelers, was the internal champion for this. And I'd learned enough from Koch and Texaco, the more reforms are coming from within, the more staying power they have. Now, of course, we had no idea that 20 years later, the people will be still talking about it. But it did lead to a record number of minority coaches, general managers, assistant coaches, and transformed the league. But the real power of diversity that I like to highlight is that starting in 2007, 5 years after we put out this report, 10 Super Bowl teams were led by a person of color as head coach or general manager. Few of them you see here, Jerry Reese with the Giants twice, and Mike Tomlin with the Steelers, who will ultimately be in the Hall of Fame, and Coach Dungy, who is a Hall of Fame head coach. And so it just gets back to, if you have a sense of belonging and inclusion, you're going to get innovations, you're going to get better results, more productivity. The Rooney Rule has been criticized a lot of late, as Michael knows, but I'll point to the fact that right now there's a record number of Black presidents of NFL clubs. They've made tremendous progress for women. You'll notice for women game day officials, women assistant coaches. There's a lot more progress that needs to be done. But I do think that those first 10 or 15 years of this movement we created and the Fritz Pollard Alliance, the organization we created, they really illustrates kind of the business case.
So a lot to unpack there. So I think it's interesting that the Texaco case and then the Coca-Cola case were sort of stepping stones to the Rooney Rule. What sort of things were done at Coca-Cola that maybe mirrored what you put into the Rooney Rule? Were there things like having a diverse group of candidates, requiring certain number of candidates at the final decision. Were those steps that you had thought about even back then with Coca-Cola?
Yeah, the diverse slate was part of our settlement with Coca-Cola. By the time we got to the NFL, Coke was just at the beginning stages of using it. They had a rocky start. They realized they had to do better about collecting data. And then they ultimately became really fantastic at kind of collecting data in their human resources. But they ultimately, it really led to a great deal of success because I'm looking at Barry, who represents defendants a lot over there, but a lot of times companies, they just make selections, what we'll call tap of the shoulder, like there's a predetermined who's going to be. And one of the biggest forms of bias we have to overcome is what social scientists will call in-group favoritism. And so the only way to overcome that in-group favoritism is to get people in the door to show what they have to offer. And we're doing that with Coke, and we were starting to get traction when we took it to the NFL.
So interesting, in 1994, I became one of the first African-American general managers in the NFL with the Jacksonville Jaguars. And when you came along with the Rooney Rule, I was sitting on the owner's side as that debate was going on, and you and John were coming into the room. So it was kind of interesting to have a bird's eye seat on the other side. And I can tell you, massive resistance.
Yeah.
But I think you were very clever and effective in embodying the rule in terms of Dan Rooney, who was very much spearheading, and Paul Tagliabue, who was the commissioner at the time. But you were very unwelcomed in the beginning, I can assure you. There were terms like pain that were constantly referred to after your name. And of course, that's often the way it is when change happens. And so that landmark case did lead to so many other African Americans getting opportunities, and but for that would not have had those opportunities. So it is significant, and the rules have expanded with the Rooney Rule, where not only is it an interview process, but 2 final candidates at the end. And as you mentioned, 6 new presidents on teams that are African-American, including women, numbers that we've never seen. The number of hires in the league office is almost 40% African-American and minorities. So there's no question that that was a landmark case. Colleges and universities also challenge the question of affirmative action programs in admissions. And there's a watershed case in the Supreme Court that's going to come down very soon. Maybe take us through some of your thoughts on that and where you see potentially the needle moving depending on the outcome of that case.
Sure. Well, any day now, sometime before now and the end of the month, the Supreme Court's going to rule on the Harvard and University of North Carolina cases that are dubbed the affirmative action cases, which I personally don't think of it that way at all. I think of it as a diversity, as a plus factor. And I think what elite universities like Cornell and Harvard and UNC and other schools are doing is really rooted in the business case. If you actually go back and look at the Bakke decision from 78 and the Michigan cases from about 10, 15 years ago, they're not justified or reasoned based on justice or equity or righting historic harms. What they're based on is the institutions to thrive want to have a diversity of perspectives and backgrounds in the student body, which gets back to the point I was making earlier about innovation and the very strong social science about a sense of belonging and inclusion leads to good ideas and innovations. So that's where, I think their history has been. However, as someone who listened to the argument, I wasn't involved in the cases at all. It's very likely it's going to be a watershed event, very likely to be seen as a major setback for inclusion. And there'll probably be some language that might be troubling in those decisions. That being said, as I'll get to later, I think they're great solutions and ways to respond to it when that decision comes down. But it's worth noting, because there's a lot of confusion, that those cases are based on the business case, those Supreme Court cases. They're not based on the moral case or righting wrongs as much as they are. The institutions thrive with more inclusion.
I wrote a book about systemic racism in the NFL after working there for 30 years. And I talked about how coaches were precluded from opportunities to be coordinators, which is the process to then become head coaches. And Brian Flores filed, was at least hoped to be a class action suit against the NFL, challenging them on their diversity hiring and that he was wrongfully terminated because of his race. Do you see that case and using the legal forum as a vehicle to push change for diversity? You've obviously been a part of that. How do you see maybe the Rooney Rule versus activism through litigation that Brian Flores has brought forth?
Well, time will tell how that plays out. First of all, I want to do a shout out for Coach Flores. I've gotten to know him over the years as a person of high integrity and conscientiousness, and things that he says I give a lot of weight to. And the other co-plaintiffs that he has. Whether litigation is the right vehicle, I don't know. I know that was what Johnny and I, when we did our report 20 years ago, we were very happy that the league was ready to sit down with us. And to me, that shows leadership. And, you know, I know they were vitriolic because I was in the room, at least the room I was in the first time. There were a lot of fireworks, but they also showed the leadership to look at it as an opportunity. So, one thing I did want to highlight is that a few years ago, I co-created with Pam Kukas, a consulting group called Working Ideal. And one of the reasons why we did that is that really litigation is just a means to get to the point of sitting down and being thoughtful and creative about inclusion. So I always kind of look at litigation as a last resort, even though I'm a litigator.
Yeah. I know that Cornell has been very much under the dean focused on diversity and bringing more students here. And I teach in this very classroom, and I find it always interesting that all the African-American students in my class come down and sit in the front row.
Really?
How does that happen? They just pass the test. And every class I teach. And I always ask the students, I said, well, it's the only class I have an African-American professor, and I want to be as close to you as I can. And so that happens with diversity. So thank you for coming down and making this consistent for our school here and for what it does to have diversity at universities. Let's move on a little bit now and just talk about the democracy case, because we've certainly seen activism challenging diversity in a very vitriolic way.
Right.
And so some of the things that have happened, bigotry and things that have happened in the political scenes, maybe talk about that and talk about how now we talked about how polarized we are on race. Where does that stand with DEI?
Well, I'd say that starting 2016, we've had a major shift that I kind of look at fighting discrimination and bigotry as like you're fighting a cancer. And in a lot of times, in a good day, it's under remission. And on a bad day, it metastasizes. An example of being under remission is that when 9/11 happened, President George W. Bush went to a mosque to say to the country, we're not going to be bigots in light of this. And that was a sign of leadership. But in 2016, we've seen now a rise of white nationalism. We've seen the violence. We've seen even insurrection. And now we've had this metastasized moment. And it's not just that it's holding people back and it's prejudice and bias. It is a threat to democracy. We are right now in the midst of a worldwide debate about autocracy or democracy. And I feel very strongly that we need to get our own house in order and respond to that threat by being a country of inclusion, both politically and economically. And I think that threat is very real. I do feel it was a stress test for our democracy that Freedom House, for example, does a lot of the studies on democracy, and they say that we're in a democracy recession, that if you looked at worldwide data on democracy, it probably peaked 15 or 20 years ago, and we're going backwards. And the trend is, in a lot of countries, to have democratically elected leaders turn their country into an autocracy. And they do that by capturing what's called the referees, the judicial system, other, reducing the power of the press, other people that are independent, breaking down civil society. And that's the pattern, and we weren't immune to it. We got it. That recession came to our country. And by the way, if you look at like democracy scholars, and there's an index that The Economist does, we're not one of the thriving democracies. We're on the list of flawed democracies. We're behind countries like Uruguay and Mauritius. You wouldn't think we're down on the list, but we're down on that list. We have a long way to go to overcome that. But the reason why I feel very hopeful is that when that stress test came, 2017, if we had been apathetic, we may have lost this republic. That's how I see it. 230 years after the experiment of democracy started here, we could have lost it. But instead, we had the Women's March right away. I don't know if anybody here went to the Women's March. All right. Very organic and spontaneous, and it created like a strength of resistance. Then there was the travel ban, where the progressive legal community was just unbelievable. Hundreds of lawyers went to the airports to give people access to the country and some representation. It was a very scary time. Being Iranian American, I kind of organized the Iranian American organizations in our country to come to my office the next day after the travel ban and to map out a legal strategy. And working with a big law firm, Arnold and Porter, and the Lawyers Committee for Civil Rights, we instituted a whole strategy on behalf of Iranian Americans. And our case was in district court in DC. We took a different approach than the other cases. What we did is focus on humanizing the discrimination, showing examples of like US veterans who have a fiance in Iran who couldn't get married here, or grandparents trying to see a grandchild, or marriages being disrupted, medical reasons. We brought all that to light. And we also showed, hey, the Iranian American community were engines of the economy, creating jobs and innovations. PhD students, brain drain. We just tried to bring all that evidence together. And when the Supreme Court heard the travel ban case, right at the beginning of the argument, Justice Breyer said, I've got 100 amicus briefs. I want to focus on the PARS equality brief, the PARS equality case, which was our case, because we had all the factual evidence. And then Justice Ginsburg and other justices kept coming back to the amicus brief, and it's in their dissents. You'll see that. So that's what we did to respond. But so many other lawyers stood up. And I think our court system admirably stood up for the rule of law. But if we hadn't done that, our republic could have been lost.
It's interesting because there's a buzzword phenomena around diversity and race and woke cultures and cancel culture. And the travel ban was certainly an example of some of the aggregation of all of that. How does that perhaps roll back some of the view towards diversity, equity, and inclusion? Do you think that's become a perennial threat to advancing DEI?
Well, I think this, wokeism stuff, that people anti-wokeism is really interesting. Just take the state of Florida. You have, is someone from Florida? All right, Florida. I mean, the largest employer, Disney, under attack for standing up for LGBTQ rights. Universities are forbidden from having DEI officers. And so the moral case keeps playing out right now as we speak. And so I do think we're in a place for, this is a jump ball moment for democracy. It really is. I think the first thing we have to recognize is that we are not, don't underestimate what we're up against. But I do think there's a pathway to succeed in a very divided country and a time of tumultuousness. And we may feel a little bit, okay now, but the rise of white nationalism, the rise of hate crimes against people in the Jewish community, the rise of hate crimes of people in the Iranian American community, the politicizing things about the DEI. That's the moment we're in.
Let's talk about reforms and sort of what we can do. Obviously, we've painted the picture, the pros and cons, the positives and negatives. But in terms of a vision forward, what's your view in
Sure.
terms of how we move in areas of DEI in a positive way?
Sure. Well, I have a lot of ideas, so I'm going to indulge you all a little bit. I appreciate your indulgence on it. I'm going to set out some ideas. Part of it is to kind of add to the marketplace of ideas, but ultimately I hope it's a call to action, because I think everyone in this room can do something to help our country, and to look at, everyone needs to be, in my view, a Democrat small d and a Republican small r. But as long as we have a clear roadmap, I think we can save our country from the challenges we have from within right now. The first set of ideas, I would call them more or less about the mindset of how we think about things. And part of that is just being honest about our past. We have probably the greatest political document ever written with our U.S. Constitution. And when you look back on it, that was 1787. That is unbelievable when you look back on it. And it's not just it's genius, but not just a little bit of genius. It is a lot of genius. All the different ways of the checks and balances and how to, they were worried about a king, the Monuments Clause, all kinds of things are tucked in there that are just quite remarkable when you look back on it. And that same document is evil, not just a little bit of evil, diabolical evil by putting in slavery. It's part of that document. And that contradiction, we haven't fully overcome that, because those echoes keep coming forward to today. So I think our first step has to be having a vision, kind of the North Star of where we're going, is to create the first inclusive, or one of the rare inclusive democracies and political economies. That's why we're on the flawed list in the economist list, not on the thriving democracies. We've got to kind of reconcile this contradiction. And as long as we have that as our North Star, I think we will go a long way. Another piece that's really important, you heard the dean earlier today, is for leaders of organizations to show institutional courage, not just check the box, not just say, hey, we're going to do something because of compliance. We're going to do something because we really believe in it, that we will thrive as an organization and put the same level of determination that they put on other parts of the business of that organization. I'm going to give a shout out to BlackRock. BlackRock, along with a lot of other companies, were asked to do a racial equity audit after the George Floyd murder. BlackRock retained Eric Holder and Covington and Working Ideal, the company I co-founded. And a few weeks ago, we put out an assessment, racial equity assessment, that is now seen as kind of the gold standard of a racial equity assessment among, let's say, about a dozen that have been done the last year or so. Well, that took a lot of institutional courage to be ready to turn over hundreds of people to talk to us, documents, and to allow an independent review of what their systems are and allow for recommendations to get better, because they're committed to that. So that's the kind of institutional courage we need from leaders of different companies. And by the way, BlackRock was co-founded by Cornell alum. So that's kind of the first set, I would say, is just the kind of mindset of how we're going to get through this. Second set of ideas I would suggest is, what are we going to do to protect democracy at home? And I kind of think of Justice Brandeis has a famous line about celebrating our federalism in our country, that we have different states with a lot of autonomy. And he called it the laboratories of democracy. Well, we actually have a lot of laboratories of autocracy right now. If you went to another country and you said, well, if you got 44% of the vote for a political party, you got 65% of the legislative seats, You would say that's not a democracy, but that's Wisconsin right now in 2023. If you said, oh, well, there's based on race and ethnicity, there's a different set of lines and how much time it takes to vote, you'd say that's not democracy. Well, that's Georgia right now. If you said that you get a legislature of one party wins and the governor of another party wins, and then you just strip the governor of power, you say that's not democracy. Well, that's North Carolina. So how are we going to get back to laboratories of democracy, like Justice Brandeis said? And I have two suggestions there. One, it's something I wrote about in 2016. And you might think, oh, this doesn't make sense, but let me just give me a minute to explain it. To overcome the division we have as a country, where there's so much division, based on urban versus rural, based on race, ethnicity, religion. The long-term solution in my mind is universal community service. And that solution would take young people and ask them to give a year or two back to the community in their states, working together with other people of different backgrounds in their state for all kinds of community goods that could be done. This has got a deep-rooted history in social science. It's that has been well-grounded, which is, intergroup contact theory. And there's legislation in Congress right now on this. Senator Tammy Duckworth has a bill on it, and Wes Moore, governor of Maryland, is experimenting with it in his first year in office. I think that's one way long-term that we can overcome some of this division. The level of division we have right now is so deep that a lot of democracy scholars and historians are saying, hey, this is like pre-Civil War. Well, we don't want to have a civil war. Well, one way to overcome that, I think, is to get people working together. And the reason why I'm very confident about that is that bigotry finds a home when you can kind of treat people and dehumanize them and they're others. But if you're working side by side in common cause with people that are different from you, it's going to be much harder for you the rest of your life to be putting that group down. The second idea I have, I'm calling it a democracy envoy. And I told that to someone and said, why don't we call it democracy czar? Isn't that a contradiction? Well, my idea of a democracy envoy is, look, we have John Kerry right now is the climate change envoy because it's an existential threat. Well, if we don't solve democracy at home, that's an existential threat. So someone needs to kind of be in a nonpartisan way, put a spotlight on things I just talked about, Wisconsin and North Carolina and so on, to put, for example, standards together of what is excessive political gerrymandering. Supreme Court says they're not going to touch that. Well, someone's got to come in and say, it's not right to go from 44% of the vote, 64% of the seats. Maybe 49-51 is okay, but someone needs to kind of put these standards together and put the spotlight on it and to fight against voter suppression. Voting is patriotic. We should all be able to get behind that. And so a Democratic envoy to put a spotlight, because I think right now it's falling through the gaps because the attorney general, the U.S. attorney general can bring cases, but it doesn't have the bully pulpit. So I think that's one between the long-term universal community service and the more urgent approach of a Democratic envoy, we can save those laboratories of democracy that Justice Brandeis was talking about. And we need to do it. We're on a worldwide battle. You just look at Ukraine. So that's my first set. The second is more economic, which is one is very old-fashioned and one is more modern. The old-fashioned one is the very first civil rights law ever enacted in the U.S. is now called Section 1981, which was enacted in 1866. So you have to look ourselves back in that time. President Lincoln is assassinated. 13th Amendment is enacted. 14th Amendment hadn't been enacted yet. Frederick Douglass is out there saying, we have these freed slaves, how are they going to get into the economy? And the very first thing that Congress did in 1866 by an overwhelming vote was to pass the civil rights law in 1866, which was to prevent discrimination what they used the phrase was to make and enforce contracts. And historians said that was a pretty revolutionary concept because it was saying, hey, we have a standard now.
Mhm.
We're going to not have a caste system. We're going to say, that privileges are going to be equalized in terms of at least opportunity, the concept of equal opportunity. And that law had great promise at the beginning, but it didn't take long, less than a decade or maybe 10 or 15 years for the Supreme Court to say, you know what, it doesn't apply to the private marketplace. And they brought in the Supreme Court, basically indoctrinated or adopted basically the Jim Crow. And that lasted for decades and decades. And it wasn't until 1968, the weeks following the assassinations of Dr. King and Robert Kennedy, that the Supreme Court finally redeemed itself and said, oh no, it actually does apply to the private commerce. But then again, the Supreme Court got its hands on the Section 1981 to add these onerous intent standards and limit the scope. So the idea of making enforcing contracts would be only the moment of the contract, not the marketplace before or after. So what I would like to see, and we wrote, my colleagues and I wrote an article for the Atlantic, and then beautifully, some of the U.S. senators saw the article and introduced into the last Congress the Economic Inclusion Civil Rights Act of 2021. Hopefully they'll do that again this year. But the idea is to revitalize the first civil rights statute by expanding the scope to be all of commerce, not just that split second of the contract formation, and to allow disparate impact and other standards that are achievable, so we can finally have a marketplace that doesn't have this kind of level of systemic racial barriers that we have right now. So those are my two thoughts on the economy.
Not so radical.
Yeah, just go back. I didn't get to the other part, which was the Securities and Exchange Commission has under review right now an idea that I've been advocating for 20 years, which is that these issues are so material to the success of a publicly traded company that there should be a metrics of equal opportunity, diversity and inclusion, that they include in their annual reports. And if that happens, that would be responsive to what investors want. That would be responsive to what employees want, what consumers want. So there's a more educated public.
And what their boards look like.
Yes.
Why don't we open it up for questions? Because you and I could talk about this probably for about 3 hours.
Yeah.
Right ahead.
Yes, no, thank you so much for your remarks. Very informative. My question is about the Texaco case. My name is Catherine Ward-Feld. I'm class of 83, MBA 82, JD 83. And I'm always interested in whether these cases affect change ultimately.
Right.
And so in the Texaco case, 1997, $150 million settlement, task force, restitution to employees. And then in 2001, Chevron acquires Texaco.
Right.
And so I'm curious your perspective as to whether the 1997 case settlement, which was clearly, I believe, indicative of poor corporate governance at Texaco,
Right.
perhaps put the company in play to be acquired by an organization that might have had better corporate governance practices. And so my question simply is your perspective on whether these cases ultimately lead truly to better corporate practices and perhaps an acquisition by another company.
Right. No, that's a lot of great insight and history there. Well, the first couple of years after the Texaco settlement, there was noticeable change, that the culture improved enormously in a good way. And I got a lot of calls from white executives and employees who were really happy about it because they had better systems, better governance, to use your phrase. But the full maturity of that settlement, though, we lost because in some ways, because Chevron acquired Texaco. We had an annual, and you can go back and find them, or I can get them to you, task force reports. But when Coke came around, we had 5 years of annual task force reports. So you could really see the progress in more detail in the Coke settlement because it didn't have the interruption of an acquisition. So the Chevron matter or the Chevron merger did interrupt, I'd say, the data you could collect on the impact of that settlement. But the first couple of years was very meaningful.
There's a couple of questions on that side.
Thank you so much for the great comments today, discussion, and of course, all your fantastic work in this field as a leader. Thank you, both of you. I have a question about your final recommendation, which was that there be SEC disclosures. And of course, my friend and former classmate, Catherine Ward-Feld, can talk much more detail about this. But the SEC, the SEC has before it a proposal to require disclosure. There's been some back and forth about this in terms of at least the E in ESG, right? Environmental, social, and governance. The E being largely about the carbon-based emissions, but yours really goes to the S and G, right?
Right.
More the S than anything else. And I wonder if you think that their approach thus far, which has gone back and forth, is a good model to use and follow. And I'll just summarize briefly, which originally the proposal was, we're going to require that all these public corporations actually come up and model their carbon footprints. And they've backed off of that significantly. And now they're just saying, well, if you've actually, our proposal is if you've actually done any modeling, you have to disclose it. But if you haven't done and don't do any modeling, that's fine. Keep it to yourself.
Well, I can't say much about the E part. I have thought about the S and G a lot more. I can just tell you that investors see these issues as material. How it gets formulated, I think, is open to a lot of debate. The example you gave would concern me a little bit because you don't want to discourage people from doing the self-assessment. What I've written about for the E part, the S part of it, is that what I think is very simple. The easy data is take the top 200 highest paid and total comp executives at a company and just tell us, how many of them are women, how many of them are people of color, because you just have that one data point that will motivate people to break the glass ceiling. That one data point. There are other data points. And if you go to workingideal.com, we've written about it. We have a whole blog about what we think the S and it is G too. It is about governance also. So companies with better governance and companies that have more built-in inclusion are going to succeed more long-term. And that's why investors care about it.
It's funny, in the NFL, when we give reports of the status of the number of minorities in senior management, we put it up on the screens in the league meetings, and that moves the needle because the owners who are at the bottom of the list get ticked off and say, how come we're at the bottom? So their only focus is competition, and they don't lose in anything.
Right.
So
Exactly.
That's an effective way to do that. I think we have another question.
Yeah, thank you very much. My name is Dave Orban. I am a father of 2 boys that are in high school right now in New Jersey. And when I listen to them speak about what they're experiencing in high school, it's almost a burnout around inclusion and diversity. The school recently passed a dress code, no tails allowed to be worn in school. They're burned out with, having to remember everyone's pronouns, and they feel almost attacked. And what's happening, and I've spoken to a few other parents, is that a lot of these kids, when they're graduating, are actually going down south. You mentioned Florida. There are a lot of people that like what Governor DeSantis is doing down. And the question is this: is there a place where we have to be concerned that some of the tactics and strategies that are being used with diversity and inclusion are going to result in a backlash. And a very strong backlash that almost undoes or at least sets back some of the progress they have made.
I think we already have some backlash. There was a brief moment after the George Floyd murder when I feel like there was a lot more consensus to go forward. But I do think that there is some backlash but that's where I come back to institutional courage, that staying committed to being on a path of inclusion, but also being sensitive towards a lot of different perspectives. And so, for example, leaders of organizations, making sure they're listening to all the different constituencies and perspectives is a starting point. So it's really important for people to be heard. And so being sensitive on those issues, I think is really important, but we're already in a phase of backlash.
Yeah. The question there.
Hi, Andre McQuillan. I'm from the ILR school, graduated in 1998. So I lead some panels and sometimes speeches in diversity and inclusion in the CBD and cannabis space in California, Colorado. And these are industries that are not yet formed yet and don't have, legal clarity in terms of what they really are federally. So I often try to just lead by example and being a leader within organizations and just try and, fight the good fight in that respect. But I'm wondering if you have any recommendations on in emerging industries like this that aren't formed legally, that are in the legal gray area, what can be done to help with diversity and inclusion, because it's similar to your Coca-Cola example where a large part of the audience and the customer base is minorities, African American, but the C-suite of these organizations are very underrepresented.
Right.
I feel like it's a similar comparable.
Well, and this interesting question, because in the work I do with Working Ideal, the consulting group, I've often brought up the issue of what about emerging companies? There's a lot of focus on big established companies that have a lot of resources, but the emerging companies have a lot of missed opportunities if they don't get good systems in place from the beginning. Because if you go from 1,000 to 10,000 and you haven't put in a good system, then you're going to be struggling. So I think it really comes back to leadership at the top, making that a value, being smart. And it's hard because it's emerging companies. They are like, oh, I don't have resources to do this. But in the long run, their success will be better if they make those investments, because it's a lot easier to do it at the early stages of a company than when the company grows and gets a lot bigger.
We have an aspiring young attorney who has a question there, I think.
Okay.
My name is Max and I'm in 6th grade. And my question is, do you think that the blindness or ignorance of diversity, equity, and inclusion for certain people will continue for generations? Like, why or why not?
I didn't get it all. We said, do you think that those kinds of conditions will continue for long?
Oh, yeah. Wow. What a wonderful question. Thank you for asking that. I think it's a lifelong journey to be on these issues, because it takes a lot of determination. And as soon as you take your eye off the mission of this, organizations are going to go backwards. So I kind of look at it, it is a lifelong journey. Your entire life will be still working on these issues. But we can get better. And I could see, one of the things that gives me so much hope is I've seen how people can make a difference. And I just want to do one anecdote because it's a Cornell Law School anecdote. I came up here to talk one day in one of the classes, and Ted Eisenberg, I don't know if anyone took Professor Eisenberg's classes. He passed away a few years ago. And I was being walked around by Stuart Schwab before he became dean. And Ted came running out like a mad scientist and said, Cyrus, I've been doing all these studies of the outcomes of court cases, the trial level with the appellate level, and no one had put a database together until Cornell did of those outcomes. And he was looking at the job category called jobs, which are basically discrimination cases. And what he found, and the other colleagues found, is that when employers win a case at trial in a discrimination case, they'll be reversed 8% of the time, which is pretty interesting because that shows a lot of deference to the fact finder. But when employees win, it's the reversal rate should be 8%, so it'd be the scales of justice.
Yeah.
But if it was 16%, you'd be alarmed. Well, it was 42%. That is just the scale of justice collapsing. So Dean Schwab came to DC and spoke about it with retired Circuit Court Judge Nathaniel Jones. And that got the attention of the Senate Judiciary Committee. And they asked me to testify with Lily Ledbetter to bring that scholarship to light and to bring stories like Ms. Ledbetter's to light, because she was an example that fit right into that, where she won at trial and was reversed on appeal. And so the punchline of the testimony was, I didn't use this word, but the way I looked at it is that we have hierarchical bias on the appellate level because the source of appellate judges were almost exclusively former prosecutors and individuals from big firms. And the bar has got so much more to offer. We have public interest lawyers. We have public defenders. There's so much more to offer. And so I called for in the testimony was we need to have look at diversity in life and work experience. And that got a little bit of traction under President Obama, but it is now the forefront, the signature approach of President Biden. And it's illustrated by Justice Jackson because her work as a public defender would be a perspective that is needed on the Supreme Court. But in all the appellate judges and district court judges, we have a lot more diversity of life and work experience. And that's an example of what a scholarship can do, the academics here at Cornell could do, leads to a Senate testimony. Now, this last 2 years of judicial nominations is completely different. And you have to give credit to President Biden and Ron Klain, his chief of staff, that they took that approach from 2008 when that testimony was and made it a centerpiece of what they're doing now. So that's why I have hope that people can make a difference.
We're going to have our last question and we'll wrap it up. To the front row.
I'm Cleo Jacobs Johnson, also class of 98 human ecology. I'm not in the legal profession, but I am on our DEI team in my organization. And a lot of what you said resonates with what we even have a modified unity rule. You have to wonder what the modification is, but that's what it's called, modified unity rule. And I have to say, as a DEI professional, the burnout is real.
Right.
And so you said so many things that's been inspiring, but I'm just curious, right? For those of us in this field, in this area, who are working to make transformative change in our organizations, how do we just keep getting up every day?
I know. Well, I can tell you what gets me up every day is our clients are courageous. We can see the work makes a difference. I personally, I'm friends with a lot of people who are doing DEI work in major companies or smaller companies. And I admire them because that is a tough job. I talk about institutional courage. The only way to do that job is to be courageous. You have to literally be willing to lose your job to do that job.
Yeah.
Because you have to speak to the most powerful people in an organization and say, you got to go a little further. You got to put some interventions in place. You have to look at the data. These are hard jobs, but those are jobs that make a lot of difference.
Well, thank you all. I really appreciate it. Hope you have a great rest of your reunion and we'll be around for a little bit. Anybody else that has a question didn't get a chance to ask. Thanks so much.